Hi, folks. I'm Denise Howell. And next up on This Week in Law, we have Fred Jennings, who is about to be Associate Corporate Counsel for GitHub. Matt Curtis and Stefan Spida are on the show as well. We're going to throw our phones in the ocean and bury our heads in the sand right afterwards. We'll discuss the legal risks of an intent to mock, and the robot apocalypse has great UI. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
This is TWiL, This Week in Law with Denise Howell, Matt Curtis, and Stefan Spida. Episode 439, recorded October 19th, 2018. Replete with Decomposing Gastropods. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. I'm so excited you're here with us this week, partially because given our rundown, I feel like I need the moral support. We've got some of the most sort of despondent technology commentary and perspective that I've ever encountered, and we've got twerking robots. So there are all kinds of juxtapositions yet to come, and we've got just a great panel of folks to do it with here today. Our guest is Fred Jennings. He has been a lawyer at the cyber law firm Tor Eklund for quite some time, and we've managed to catch Fred between jobs as he's getting ready to move out to the West Coast and become Associate Corporate Counsel for GitHub. So thank you for taking the time to joining us, Fred, as opposed to packing, say.
Absolutely. Thank you for having me. And I welcome the distraction from my life of boxes and clothes sorting.
Yes, we're happy to do it for you here. I can't say that we'd be much help at the boxes and clothes sorting, but we're going to be great at distracting you. Next up on our panel today is Matt Curtis, founder of Pareto Life Sciences, a law student on hiatus, and lover of all things blockchain. Hi, Matt. How are you doing?
I love that you threw that in there. Yeah, so
yes.
I'm really excited that you get to go work at GitHub. That's great. I think it's one of the best services that's come out in the last decade. So it's really exciting that you get to go work there.
It is. And before we dive into our stories for the week, I'd love to just spend a little time exploring your career with you a bit, Fred, because you've had some very fascinating paths that you've taken. Also here with us is Stefan Spida. He is with the Dorsey & Whitney firm in Seattle, Washington. Hi, Stefan.
Hi, Denise. And, it just occurred to me that it'd be great if you could introduce me as founder of nothing, because I founded nothing. And I kind of like the nihilism implied by that.
I do too. Somebody has to found nothing. Somebody has got to be responsible for the nothingness. We need the empty spaces in the world. And maybe that's why we're all going to give up our technology as well. All right. Well, so we're going to start off with some crimes and justice stories in just a second, because it jibes well with Fred and his expertise. But let's talk about your career and the Tor Eklund firm in general, and Tor Eklund, the person. We were talking before the show. We've had your partner, Mark Jaffe, on the show a few times, I believe, in the past, and should have him back again soon. I am reminded we will have to reach out to Mark and see how things going. But first, describe the firm you're leaving and why it's special.
Yeah, sure. Tor Eklund Law has been a fantastic place to be, and it's among the only places I'm aware of in the entire country doing cybercrime defense with sort of a focus on hacktivists and sort of those smaller pro bono cases as opposed to like the large corporate civil CFAA suits you see out there. So it's been a fantastic place to be sort of at the cutting edge of this very poorly defined and very broad cybercrime law for the last several years.
And it has been just you and Mark and Tor, correct?
For the last few months, yeah. We've had, in the past, there have been some other junior associates as well, and we've had the odd intern here and there, but it's been the three of us plus sort of business side and support staff for the last while, yeah.
And lest anybody is curious about another thing that we were talking about before we started the show, Tor did not change his name to Tor when he decided to do cyber law. Was born with the name. Very cool. All right. So describe some of the cases that Tor Eklund's been involved in.
Yeah, I mean, I think there have been, several of the kind of higher profile CFAA cases that we've worked on include the Matthew Keys case. We represented Derek Lostutter out in Kentucky. I was one of the main attorneys on Matthew DeHart's case, who's a whistleblower. The main case was down in Tennessee. And then trying to think, I mean, the other sort of notable cases that, I worked on, the firm has handled, we were defense counsel on the first London interbank offer rate white collar case in the country against individuals. And we've done a few other, less, I think the cybercrime stuff is the, headline making cases we've worked on, but we've handled a good number of, copyright disputes and trademark litigations and things like that as well. Right.
So you are cyber lawyers and IP lawyers who also litigate, which is sort of an interesting and not all that common blend. Or you were, because now you're moving in-house with GitHub. Tell us a little bit about that and what you expect that to be like.
Yeah, sure. I will know more after onboarding next week, but my impression is that unless I really screw something up, I will not be in court nearly as often. So it's primarily a transactional, standard in-house position doing support for, sort of the legal department as needed.
Right. So we have a pretty tech savvy audience here, but just in case, my dad will listen to an episode from time to time, and I'm sure other people who have never heard of GitHub are wondering perhaps what GitHub is. Can you describe what it is?
Yeah, sure. My favorite sort of go-to non-technical description is it's a tool for doing distributed software development, which I think is sort of the in a sentence shortest definition I can give. But they manage a variety of products and hosted services for primarily open source development, but a good deal of other sort of software projects to do, track changes for your software in the cloud.
So I'm sure that GitHub faces all of the legal considerations of any company, but are there also special attention that you pay to intellectual property issues because of the open source nature of what GitHub does?
I mean, yeah, you're sort of at the intersection of open source software licensing issues and copyright issues. And a pet passion project of mine for a while has been software copyright and doing sort of advocacy and educational work on that on the side. So I'm excited to be going somewhere with sort of a lot of focus on those issues and a lot of sort of arms in the policy problems of today in that area.
Yeah, it's really fascinating. We're excited for you too. We're excited for your move, and we've already extended the invitation. Come join us on TWiL again sometime so you can go up to the Petaluma studio, which won't be that far from your new stomping grounds. And it's always fun to participate in Twit's offerings from Twit Ground Zero. All right, well, let's move on to, as I said, some crimes and justice stories. Fred, a lot of the bread and butter work that you've done at Tor Eklund, as you mentioned, have involved the Computer Fraud and Abuse Act, the CFAA, which is the United States' primary anti-hacking law, enacted quite some time ago. Was it the 80s that it was enacted?
The mid 80s, yeah.
Mid 80s. Without too much adjustment or tinkering since then, but a lot of hand-wringing about reforming it, because it leads to ridiculous situations like the one we saw this week, or was it late last week, when Kanye West visited the White House and was much mocked and maligned when a camera shooting over his shoulder caught him unlocking his phone so he could show something to President Trump, and captured for the world what his password was. It turned out his password was not very secure, and a lot of people took the opportunity to reshare that password and make fun of Kanye West for his lax phone security hygiene. What's the problem with that when it comes to this law that we're talking about, Fred?
So there were quite a few posts noticing that this could be a CFAA issue, and I love this as an example issue because it's sort of your perfect law school hypothetical type of issue where I think the odds of it actually being enforced and actually coming, hitting the ground for someone in even an investigation is incredibly unlikely. But at the same time, there's enough wiggle room and enough breadth in this law that you can kind of explore the possibilities. The CFAA does have a subsection that covers sharing passwords, essentially. I want to say it's 1030A6, but I could be off on that. The important detail and I think Kevin's article there that you've got up on the screen, I think may go into this, but the important detail is that A6 requires that the sharing be done with the intent to defraud. And that's a legal concept and legal doctrine much older than the CFAA. And, the problem there is what can be used to attempt to prove intent to defraud is pretty broad. You don't need a specific, clear, explicit statement saying, give me money or I'll share your passwords. You're allowed to prove this through kind of circumstance and context and action. So, it's the sort of thing where crafting an indictment that would charge that wouldn't be that hard. Actually proving it to a jury in a way where, those 12 people are not going to go back in the jury room and laugh at you is much more difficult. I did not see anyone tweeting this saying, oh, I've got Kanye's password, and if he sends me $5 million, I'll delete this tweet. Most of this was sort of innocent, haha, look at this terrible password kind of sharing. And I think the bar to prove intent to defraud in that kind of context would be incredibly high. So, neat hypothetical issue, actual likelihood of risk becoming reality for someone, I think quite low.
Yeah, I'm sure that what a jury would look at this and see, I think, as we all do, is an intent to mock rather than an intent to defraud. But the point about the CFAA, I like your distinction there, too, of how an indictment is different than a verdict and why that matters. You may, after you've gone through, the lengthy process of ramping up a defense team and trying a case, find yourself not facing liability under this statute. And perhaps we should remind people what the potential downsides of getting convicted under the CFAA are, Fred?
Sure. I mean, assuming a felony conviction, you're talking, depending on which subsection you're charged under and convicted under, and again, assuming only one charge, which is usually not the case, you're looking at 5 or 10 years, or I think if we're going for kind of the nightmare scenario hypothetical, there is a provision that allows for life in prison if it is unauthorized damage that leads to loss of life.
Oh, dear Lord. So if you've rolled the dice and found that Fred was right and you've prevailed, it's a terrible process to get to that point. Merely having a federal felony indictment against you is quite an onerous thing. And if it could conceivably be applied in a situation like this, we're talking about a law that probably needs to be revisited and reformed. What do you think, Stefan?
On the hypothetical that we've been discussing here, there's an interesting argument that I think I would have tried to make if this ever actually got litigated, which is that Kanye is the one who shared his password, and the people on Twitter were just commenting on the sharing. And if in the course of commenting, they simply included data that was shared by Kanye, that seems not to ground a basis for violation under the statute. That, I mean, I don't know if that's actually sound law, but that would be my argument. That, you know, I try to analogize it almost to like a trade secret framework, where once you've released the trade secrets and you've done so yourself, you can't kind of put the the rabbit back in the hat. And in this particular case, you know, Kanye held up his phone to a camera that he must have known was being broadcast nationally and put his password. So I think if it were me litigating this, I would say that was the act of sharing, and anything downstream from that could not have been a violation. Any thoughts on whether that's a sound argument?
Well, I've seen the clip of Kanye unlocking his phone, and it seemed to me like he was doing so without any consciousness that he was sharing the password, that he was simply, you know, punching it in so he could then get to what was on it and show the president. So, I mean, obviously in that situation, you should be aware that you're being filmed from every conceivable angle, including over your shoulder, which is how this was captured.
Right. I mean,
but yeah,
like with a trade secret, you know, there's no, it's not just, you have to take reasonable measures to keep it secret. And in this case, you know, could you see a password a similar way that, you know, if you're carelessly inputting your password while being videotaped in the Oval Office, can that be construed as an act of sharing? And I think it seems like a pretty good argument that was the act of sharing. And so there's no violation.
Maybe we're going to talk about some Face ID issues next. Maybe Face ID is Apple's way, and other phones that use the technology, their way of protecting us from the CFAA, but it puts us into other hot water in turn. What do you think, Matt?
I think he may have had that entire conversation without like conscious thought. So the fact that he merely put in his thing, I would say that probably was not a conscious decision. But yeah, I mean, I think it's an edge case. I think that Stefan makes an interesting argument. I think that would work more for like the news camera who recorded it and sent it, and therefore they didn't have any intent to defraud. But it seems like, you know, if I, you know, like you take the Pentagon Papers, for example, if I had gotten the Pentagon Papers back in the day and then retweeted them, I would have had the intent to do whatever, even though, you know, maybe First Amendment protects it because, you know, mocking Kanye is a First Amendment right or something like that. But, you know, yeah, I think the interesting thing, if I would have put whatever Kanye's Twitter handle is and said, hey, your password is really dumb, please change it, you know, would that have gotten me out of it? But once again, it's an edge case and it's kind of fun to talk about.
So I guess as a public service to all the law students who will no doubt face this hypothetical, I think you're dead on with that, Fred, that law professors everywhere are going, yay, I have something to put on my exam. We should issue spot for them too, that perhaps the photographer, videographer who captured this should be thinking about liability for both for sharing the password and perhaps for some sort of privacy violation. We seem to have more and more momentum toward what people can or should do with information that they've captured about other individuals in public. I'm thinking back to the Plain Bay story, the thing that got blogged and videoed of a couple on a plane. They weren't even a couple. They were having a conversation across the aisle. And people came down like a ton of bricks on the person who sort of created a story from what she videoed in front of her on the plane. And the people who were involved were not happy about it, even though they were captured from the back and not identified by name or even by their face. So I think the photographer's liability is something to consider when you get this on your exam. And also, I think it's hilarious that none of us will say what Kanye's password was. Because who wants that federal indictment? All right.
Because it's not... If that's the password, it's not even a password at that point.
That's true. All right. So as long as we're talking, this is sort of our gateway drug to talking about the CFAA, which is something that Fred not only has done, but thought about and litigated throughout his career. We were going to talk about a couple of cases in particular before we move on. Fred, tell us about the Keys case.
Yeah, sure. And this is a good segue from talking about this Kanye password sharing, because you pointed out an important difference between the CFAA and the trade secrets statute, which is the CFAA doesn't really care how you got the password. With Matthew Keys's case, what he was accused of was having essentially shared passwords that he'd had as a former employee at a news company in an IRC channel that was, full of folks who, at the time, I think this was still the sort of internet feds era. Several of them went on to become what was known as lulzsec, and it's sort of this whole hacking ring from the sort of early anonymous era. And these were passwords that, at the time he was fully authorized to have, and would have been authorized to use, I believe, while an employee. And then he was let go. The story in the indictment goes they happened to not have changed those passwords, and someone then went and defaced an article on, I think it was the LA Times website, not in any sort of disinformation-y way, just I would describe it as lulzy. But it was changed for all of 40 minutes before someone noticed and rolled it back through the content management system to the previous version. And Matthew was hit with a multi-count Computer Fraud and Abuse Act indictment. I think sort of the main arguments being around being part of this conspiracy to commit unauthorized access and unauthorized damage to the LA Times website. And he was ultimately convicted and sentenced to 2 years for someone else's defacement of a website that lasted 40 minutes.
And Tor Eklund represented him?
Yes, we represented him at trial and on appeal.
Where did he have to serve his time?
I'm forgetting which facility it was. It was somewhere out west, I think in California, but I don't remember off the top of my head. I'm sorry.
But he did do 2 years in federal prison.
Mm-hmm.
Wow. Okay, let's talk too. So there, you can definitely distinguish between mocking someone for having a weak password and posting passwords that you were authorized to have and use to third parties who were not, who you knew would probably have fun making use of them. Again, it really kind of sounds like an intent to mock as I talk that through. Although you wouldn't know as Matthew Keys what use would be made of these passwords. Mm-hmm. So let's talk about the intersection of the CFAA and the First Amendment. I swear I keep seeing the First Amendment pop up in the strangest places these days, and you really don't think too much about an intersection between a hacking law and the First Amendment right at first blush. But tell us about the Sandvig decision.
Sure. So there's a lot of context in which the CFAA and the First Amendment sort of intersect. The Sandvig v. Sessions case is one of the, I think, best examples in a civil case. And I should clarify that this case, as far as I understand it, and correct me if I'm wrong or if my information's out of date, but as far as I understand it, the case is not done. There wasn't a sort of early stage decision on Sessions and the other co-defendants' motion to dismiss, which basically said that yes, there is a First Amendment interest in the kind of research that Sandvig and the other co-plaintiffs were doing. To explain the background of the case, this was brought by, I think it was ACLU, on behalf of several academic researchers who were looking into housing discrimination on online platforms. And so in traditional housing discrimination cases, what would be done is you write out an application to the broker or the real estate agent, with multiple applications with similar statistics, credit ratings, what have you, but a name or some other demographic information that hints at race or gender or religion or some other protected identity status. and you see, you sort of do a statistical test of, is there a disparity between their, approval or application rates for, folks that code a certain way in the way their application looks and people that code a different way. So this was applying the same idea to online housing applications. And these academic researchers and organizations wanted to look into whether that was happening, but realized that in several U.S. jurisdictions, there is still case law supporting the notion of a sort of contract or terms of service-based interpretation of the Computer Fraud and Abuse Act. So it's a minority doctrine compared to other interpretive frameworks for the statute, but the concept goes, if my terms of service on my website says you may not log into this with a fake name or a pseudonym, and I do so anyway, this doctrine says that is no longer authorized access because it's being done in violation of the terms of service. So there's a lot of issues with that. The First Amendment one in this case is the notion that this research is protected by the First Amendment, and that there's sort of a First Amendment political speech right to do and to publish and to be able to publicize this research. And then this conflicting issue of, at least on paper, this is research that would violate the CFAA in circuits that either follow or potentially follow the contract doctrine of authorization theories.
Right. So for folks who haven't wended their way through law school, the reason how the First Amendment is operating here is as a potential check to the CFAA. The Constitution is the mother of all laws in our country. And if statutes violate the Constitution, they may be found to be unconstitutional and invalid either in whole or in part. So that's how this could become important as a constitutional challenge to an existing statute, one that has been around since the mid-'80s, as we said. So I think that's a really fascinating way that this comes up. And actually, again, now that we have sort of talked through it, perhaps the, again, public service announcement for the law students who will confront the Kanye hypothetical, perhaps the First Amendment argument should be asserted there, that your intent to mock is some sort of protected speech that would invalidate that part of the CFAA. What do you think, Matt?
Yeah, I just want to draw, I think that the question was raised is why is the First Amendment popping up on all these contexts? And part of the reason is just that the First Amendment has a better level of scrutiny. So a key analysis, they brought both a First Amendment and a due process challenge. And just to highlight that the First Amendment, you get what is called heightened scrutiny. And sometimes in some contexts you get intermediate scrutiny. But basically, if you can prove that there is a violation, even if there is a compelling government interest, they have to have a narrowly tailored way of implementing that law, or sometimes that's called the least restrictive means. That's a really high burden on the government to craft a law that is not going to infringe upon your rights. This was an as-applied challenge, so it's even more difficult in that circumstances because they're not asking to invalidate the law entirely. They're just asking for the court to say that this provision is invalid as applied to what I want to try to do. If they had tried that on a rational basis, the question would have been, is there any rational basis at all for the law to exist? And there's a famous 1955 case which said that not only does the government able to come up with a rational reason for a law to exist, but if the court can't come up, or if the government can't come up with that reason, the court is obligated to come up with that reason, and that was Williams v. Lee Optical. So it's a just incredibly high standard to meet, and that's why we saw it in the trademark case. And for the slants who we had on before, we saw it in Pickering, which was we've talked about it in whether the First Amendment protects sexual abusers' right to be on the internet, essentially on Facebook. It's just an effective vehicle to bring these challenges, and that's why it's being used.
I'm so glad that your hiatus from law school has only been a brief one. Matt, thank you for all of that. Stefan, any thoughts?
Yeah, I think, has anybody looked at how this case dovetails with the Ticketmaster case with the Hamilton bot purchases? Because there's some interesting overlap with copyright law as well, where you can kind of do this vicarious liability pleading to get around some of the 12b6 bars to bringing these kind of cases for having bots gain unauthorized access to a website. And, the background there is similar underlying issue, whether terms of service can be used to enforce access in a way that, basically if you have terms of service that say you cannot log onto this website and do anything contrary to the way that we want you to behave while you're on this website, how much punishment can you face for violating those terms of service, and can it include copyright infringement? And in the Ticketmaster case, the way that the complaint was pled initially, they found that they were not able to successfully plead a claim. And so then they came back, they amended the complaint, and they did this kind of complex vicarious liability theory, and they were able to survive a motion to dismiss. It seems to me it's kind of similar to this the Sandwig case, because the underlying issue is quite similar. You've got violations of terms of service being expanded quite broadly. And so I'm wondering, is this the only statutory context where this comes up, or are there other areas that dovetail with this that we could look to for guidance as to what sort of the proper scope is of allowing private companies to craft terms of service that will then have implications well beyond simply accessing the website?
Fred, any thoughts on that?
Yeah, this comes up not infrequently with CFAA cases and other kind of online conduct cases. And one of the big criticisms about circuits that have adopted, or at least not explicitly done away with, the contract interpretation of CFAA authorization is the idea that there are, centuries-old legal doctrines that say, you as a private person don't get to make the decision of what is and isn't a criminal violation. So one of the big picture criticisms is that by empowering, the terms of service contract, or the EULA that no one reads, with the power to determine whether something is or isn't a felony, one of the sort of as written challenges that's been levied a few times against the CFAA in this context is that interpreting it that way creates a power that is sort of not permitted to an individual or commercial entity.
I'm curious, Fred, to get your thoughts on a different potential application of the CFAA. And I think I already know the answer, but it occurred to me when we were discussing the East Bay Killer, or Golden State Killer, I think has been tagged with both of those monikers, where he was apprehended because law enforcement was able to use a DNA database, did not subpoena the information from the database holder, but rather created an account, submitted some DNA saying, this DNA matches the account that I'm creating, and was able to match up and apprehend the guy. And I'm sure that's not the only instance where that has happened or is happening. So it seems like law enforcement there is violating potentially. I mean, I'm assuming that most of these databases would be set up to discourage people from creating false accounts. So as I wend my way through this, I'm thinking, law enforcement gets a free pass from violating the CFAA in these kinds of circumstances, but should it? What do you think?
Yeah, it's I think an important question, especially as we have more and more databases of biological or biometric information online. Whether it should get a free pass from CFAA liability, I think that's one, in the absence of sort of a federal level biometric privacy statute. I think it's one of the few tools that people have to push back on sort of misuse or deceptive use of these databases.
Yeah, there are other felonies that law enforcement is not entitled to commit in the course of their doing their jobs and can be sued if they do commit them. So it occurred to me as a potential thing that could pop up in the future. All right. Speaking of popping up, what pops up increasingly as people pick up their phones is special technology that reads the biometric information in their face and unlocks their phone. I believe we talked about this a couple of weeks ago, but wanted to bring it up with you too, Fred, that we have the first instance, widely reported instance anyway, of a suspect who was told by he was basically just his face was put in front of his phone to unlock the phone so that the officer could get whatever information the officer could get from the unlocked phone and continue the investigation. Apparently, the officer did not keep the phone unlocked for long enough to get too much information, and didn't also collect the actual password, which let's hope was more secure than Kanye's. So it didn't wind up doing too much good. But this whole idea of just, hey, look at your phone, and what that means for Fifth Amendment jurisprudence and how it's different than asking for someone's password is something that we've covered on the show throughout the years. This strange dichotomy between biometric security versus password security, and it seems like the courts of the land are still they don't think it's a strange dichotomy. They're happy to let the dichotomy exist, and law enforcement is sort of pushing ahead on both fronts. Fred, what did you think of this particular face unlocking issue?
Yeah, it's a fascinating issue because I think you're right. By and large, the courts of the land have leaned sort of heavily back into traditional Fifth Amendment distinctions between items of knowledge and physical action. And, to briefly law-splain on that, it's the idea that the password that I have memorized, I cannot be forced to divulge that because that's testimonial. But, the fingerprint that the police tell me to put on my phone, that's a physical act and thus non-testimonial. I'm aware of, I think it was one case in Illinois, I want to say, where a magistrate judge found otherwise on a motion to suppress that came before them and said, I don't remember off the top of my head what the exact sort of detailed reasoning on the case was, but said, Face ID style unlocking should get the same kind of Fifth Amendment protection because it's revealing or requiring sort of the same concept of security that a password does. And it was appealed up to the district judge. The district judge overturned it on the kind of typical legal reasoning that we've seen elsewhere of, no, that's a physical act and just fine. And I think it's an interesting point of tension between sort of conceptually what we think of the Fifth Amendment protecting and or the Fourth Amendment protecting and the actual mechanics of that law. And I think that's what I find fascinating about it is it's kind of mismatched because the technology all of a sudden works in a way that the people writing these laws and even writing these cases, 2 decades ago weren't even thinking about.
Right. And I think the people making the technology aren't thinking about the ramifications, that Apple's not sitting there designing the iPhone 10 or other phone makers that also have this technology. They're not thinking, oh, well, we're going to have to build in some way to turn this off so that people can protect absolutely under the uncertain law that we have in the land, their Fifth Amendment rights. It probably occurs to nobody during the design and production of these devices. Matt, what do you think?
Yeah, so I think that there's two really interesting things here. Is that in another one of our articles that we were looking at if the if the facial recognition not just happened once, but if it happened repeatedly. So they were in that instance, it was looking at how many times you have to not have the facial recognition work to then have the password not work. But if you had a continuous facial recognition that was continually unlocking it, I think that you would get into more interesting cases rather than just a singular look. Your physical attributes, whether it's your biometrics in your thumbs or whether it's your face biometrics, hasn't been considered a Fifth Amendment problem. But I think it would be more interesting, for instance, if you had a case where if your eyes were closed, then it would lock your computer or lock your phone. So then in that instance, the police officer would have to hold the phone up to your face, and you would have to keep your eyes open. I think that would draw a compelled sort of instance. I think the court would have a hard time to do that. I think the other interesting strain on this is that in the Carpenter decision, Justice Gorsuch really wanted them to rule on the grounds of that it was a search of your papers. It was a property rights analysis of the Fourth Amendment, which specifically prohibits the search of papers. And I think that at least for his analysis and perhaps Kavanaugh's analysis in that realm, you're going to get into the case where how isn't your search of your phone the search of your papers, and it's a property rights violation. And I think that's another interesting way to draw this line. But I think, I think that, as these gets better, I think Apple will be thinking about how do we make this a violation. And I think a continuous authentication, every 15 seconds or every 30 seconds you have to look at your face, I think that poses a much, much more difficult hypothetical for the police.
Yeah, just to clarify, though, I do think that the way that at least the iPhones work, your eyes do have to be open for the biometric Face ID to unlock the phone. And apparently, I
think it'd be really difficult to say that you have to open your eyes, because that is very like you having to say what your password is.
I see what you're saying.
I think that would be a difficult, like if you just sat there and had your eyes closed and didn't open your phone, I think that would be a really, really difficult case.
Again, the number of people who would get, that's what they needed to do is probably very small and probably pretty hardened, that they're thinking that far ahead that should this ever happen to interrupt my criminal activities, this is what I need to do. This piece at Forbes that Fred is quoted in has an additional little detail about how Face ID works that I was not aware of. Apparently it has a liveness feature where it tries to determine whether or not the person is alive, not only whether, because you could be dead and your eyes open, obviously, happy Halloween, but it's trying to determine if that's the case. And if so, it's not going to unlock for you. I'm curious to know how well that works. Per Forbes, Apple's tech has liveness detection that attempts to determine if the visage looking at the device is alive. Again, we could spend all day, I think, talking about the rights of the dead, which are not many, but we're not going to do that today. Stefan?
I think this, to a layperson listening to this conversation, and I think it must be incredible for them to think that what hangs in the balance of the Fifth Amendment rights that you have against self-incrimination with something like a police search of your phone is whether or not the technology requires you to open or close your eyes when you're looking at your phone. I mean, just take a step back for a second, take off your lawyer hat, and think about how absurd that sounds. It's really stunning. But I think, from my perspective, it seems nuts to distinguish inputting a password and using your face on constitutional grounds. I think that's a distinction that is so unwieldy and requires such intellectual hair splitting that I'm not sure how it can be maintained. The thought that a face without speech communicates information that is quasi-testimonial in nature, I think is non-controversial to anybody who's ever had a conversation. Mm-hmm. And for it to have constitutional consequences, whether or not a word is being spoken, to me just is so bizarre that I actually do find this fascinating and a little bit, it's a good entryway, I think, for this discussion for people who aren't necessarily lawyers to kind of understand just how difficult some of these decisions can be on a constitutional level. So, my own view, not necessarily informed by a deep analysis of the constitutional principles, but just basic common sense, is that non-speech communication can be testimonial in nature, depending on the context. And in this particular context, when it's being used to unlock a phone, and it has there's no policy justification for treating it differently than an input of a password. It is ludicrous to treat facial recognition as different from sort of pure testimonial input of a password. So I hate to think that our rights hang on the balance of this type of analysis, but unfortunately they do.
Yes, because as you say, nobody's thinking along those lines, and the function is precisely the same. If Kanye had Face ID on his phone, no one would have had the occasion to mock him because it's more secure. Kind of hilarious footnote to this discussion from a piece by Joseph Cox at Motherboard. Motherboard apparently got a hold of some training slides by a mobile forensics company giving tips to investigators. And one of the tips they gave him is, if you are going to, hold up the phone to unlock it, don't hold it up to yourself. Be sure and hold it up to the suspect, because after 5 attempts, the Face ID system will lock you out and ask for a passcode, which we already know has a higher Fifth Amendment protection. So I just thought this was hilarious that as part of this interplay between confusing law and ubiquitous technology, investigators are having to be trained not to look at the device themselves. Fred, did you have any thoughts on this?
Yeah, I think I'd push back gently on the idea that Apple isn't thinking about this. I think features like that show that they are putting some increasing thought into how do we design this in a way that maximizes user convenience, but also takes into account the security that we're trying to provide. Yeah. I think their more recent phones also have a feature where if you tap a certain button a certain number of times, it will re-enable the passcode and turn off Face ID for either permanently or for a certain period of time. And, I think all this kind of highlights what Stefan's saying about where, this is sort of a ridiculous kind of intellectual hair splitting about what method of protection you're using, but it's still one that has a lot of legal power. You've got cases going back to the difference between a combination lock and a key on the same kind of concept. So if Apple's listening, what I would like from a purely practical perspective is an alternative Face ID login where if I make the right silly face, it will wipe the phone. Because then, which type of face I make, I think actually sounds more testimonial than just put your face here.
Yeah, absolutely. I put it on the feature list, and I think I'm going to put our first MCLE passphrase into the show. It's going to be "make a silly face," because that's nothing short of brilliant, Fred. And we put these phrases into the show in case you are a lawyer or other professional who likes to watch or listen to our show for professional credit in your field. If you are a lawyer, if you go to twit.to/MCLE, we have some resources there that we hope will help you out. And if you're not a lawyer and you need our help in some other way, just reach out. I'm Denise at twit.tv, and we're happy to help you. We put 2 phrases into each show so that if you have an oversight body that needs to know that you watched or listened, you can demonstrate that you did, because there's no other way to get these phrases out of these show. They are inserted at random and purely a function of the discussion that we're having. So let's move on to talk about something we talked about last week, or just a PS to something that we talked about last week. There's a piece at Above the Law that was covering fitness trackers becoming more and more involved in the solving of crimes, with a chilling thought at the end by the author, Tony Messina, that we didn't quite think through and arrive at, but Tony did as he or she was pondering this situation. And And what this reporter has said is, I wonder how people seeking to mislead the police will profit, knowing that these wearables can include things that become evidentiary ultimately. Let's say a jealous husband wants to frame his estranged wife's lover for a crime. The husband puts his Fitbit on a sleeping friend to show he never left the house, while in actuality, he snuck out and killed his ex. Returning later, he could put back on the tracker and make it look like he'd been sleeping sound as a baby. And now that I've thought through that diabolical plan, you can think of all kinds of ways people could try and fake the fitness tracker data. Presumably, if you are a killer wearing a fitness tracker, not only is location relevant to proving that you did the crime or didn't do the crime, but so is your own heart rate and biological data. So again, another reason why you might want to put the device on a sleeping friend. Fred, what do you think about this?
I mean, I think it's a great example of some of the dangers of relying too much on sort of technological data taken out of context. I see this. I've seen this quite a few times in other contexts in CFAA cases where you've got network logs that say this person was logged in, but nothing to show that that was in fact this person's account, that this wasn't a stolen login authentication or spoofed IP address or spoofed MAC address. There's all these details that question the fallibility of this kind of data, whether it's your Fitbit's snapped to a sleeping friend or falsified server logs. We put a lot of faith in this data that looks very solid and real, when the reality is that without context and without corroboration, all it is entries in a spreadsheet somewhere.
Yeah, absolutely. Matt, any thoughts?
I just think that Tommy Lee Jones is looking for a new movie, and that there's always examples of ways that since history has started, that ways that if you want to get away with something, there's definitely ways to do it. So The Fugitive Part 3 is my recommendation.
Love it. Stefan?
I love The Fugitive. I don't think I would watch Part 3. It sounds boring.
I don't know. It would be very data driven. I don't know if they can make that quite as action packed or not. Before we stop talking about crimes and justice, I just wanted to check in with you. Fred, you went to DEF CON this year. You wrote up your takeaways from that, and I've put those in our discussion points. If people want to look at them in more detail, that's at tagpacker.com/user/thisweekinlaw. We are on episode 439 this week. But while you're with us, you want to give us your primary impressions from DEF CON this year?
Yeah, sure. I admit that the notes that I think you pulled from the Torqueland Law newsletter were more stream of consciousness than I thought they would be going public with. But no, it was an absolutely wonderful time. I try my best as a lawyer in this space to keep up to date with what's going on a technical level as well, because I think we've seen a lot of bad law come out of bad understanding of the underlying technology. And I'm sort of mindful of trying to avoid that. But I think one thing that jumped out about me about DEF CON in particular was there were quite a number of lawyers there. I had some wonderful conversations with several of them, saw some talks that several others did. And, I think there's, in some circles, I think lawyers get a bad rap in the technology industry as, the folks in that office over there who say no, or the folks still running fax machines in 2018. And it was nice. It was nice seeing and getting to talk with lawyers who are, sort of really doing their best to stay in this area and get in this area of sort of the latest cutting edge of technology and privacy. And likewise, it was nice seeing and talking with folks on the technology side. And I think folks in information security are especially conscious of this with the CFAA and other kind of daily life legal issues that come up in that area. It was nice talking to people who understand, we having a conversation here is important, because these laws hit the ground. These laws become very real very fast especially if you're not thinking about them.
Right. Well, you do think about them all the time. I'm wondering if anything at DEF CON took you on by surprise and sort of scared you.
Oh, that's a great question. I think the scariest thing I saw was the corporate responses to some of the announcements around the voting village. I think there was one from I want to say there was one from one of the manufacturers of the voting machines, but there was one I think also from some entity involved in overseeing voting process and ballot procedures. And, it was this sense of, all right, we've set up this village so that specialists in this area can play around with these machines and see what could potentially be done on, I think, the very common sense notion of, well, if this is what some professionals with some background in this can do over the course of a weekend, basically, go ahead and imagine what a professional nation state actor with all kinds of political interest in election manipulation could do. And the industry and government responses to this in press and on social media seemed very dismissive. And I think for anyone whose task is to protect democratic process, that's a really frightening thing. You'd hope that these things would be taken seriously and engaged with in the way they're meant to be, and not just kind of swept under a rug.
Okay, Stefan, anything to add?
I unfortunately was unable to attend DEF CON this year. The invitation must have been lost in the mail.
I don't think hackers stand on invitations. You show up, you ask forgiveness, not permission. You're all good. Of course, if your password and other security is not good, heaven help you. Matt, anything else?
No, I didn't get the opportunity to go either. I do think it's from a technical standpoint, the issue of elections is rather absurd. It's a structural issue too, of that we have local administrators that are in charge of buying these things, and it leads to like a fragmentation of the market. But ultimately, how are you going to get the American people to trust one purveyor to? I think that all things considered in elections, it's just a really complicated issue of how do you get everyone to trust a unified offer? I mean, think about it. We use Amazon 1 million times a day and they get 99.99% of our orders correct. And unarguably, it'd be better to have Amazon do it, but no one's going to trust Amazon or some corporation to do it. Although we do trust these corporations to do it anyways, we just don't. There's not name brands.
This is slightly off topic, but I'm wondering if anybody saw the segment on Trevor Noah. They have a new contributor. I'm not remembering his name, but he is young, and there is the word young is in his name. He looks like he's in his late teens or early 20s, and he came on to do a segment on youth participation in elections. And very funny. I recommend it to you to go find and watch the segment, especially because their trope was that Trevor Noah was lumping himself in with the young people, and the new contributor was fast to point out, no, Trevor, you're not young. You're far from it as far as the people I'm talking about. And the crux of the explanation for young people not voting is because of the logistics, that, there's paper involved. That's how we're voting. I believe he said, I don't even use paper to wipe my, what. So I do think that, Matt, you have a strong point that if we can figure out secured transactions in other areas, God knows we need it in this area in order to engage all parts of the electorate. Let's move on and talk about privacy. So we're a few months into the GDPR's being live and capable of enforcement. And various investigations are going on So far, nobody has been hit with that huge potential financial penalty, but we thought we'd bring up a couple of the instances that are being investigated and just let you know they're out there. Twitter is under formal investigation relating to its T.co links, the shortened links that get generated. That apparently there's a researcher in London, and I'm sure he's not alone, who has prompted this investigation because he wanted to get all the information about himself, including information about his browsing available from those links. And there's some language in Twitter's terms of service that talks about how those links can be used. And so it's sort of a black box. Nobody really knows what you're able to tell about off Twitter browsing if you're clicking through on those links. So it will be interesting to see if the GDPR enforcement bodies decide that is information that Twitter has to hand over. Twitter declined to hand it over and said, I forget exactly what the language is. There is an exception for if something is very, very onerous on Twitter's behalf, it might not have to hand it over. But if that information relates to a particular individual's data, then that exception does not apply. And that apparently is what will be tested as the Irish enforcement body goes further into this. I was actually sort of surprised and interested that the shortened links would and could be used that way, but I guess I shouldn't be. Fred, any thoughts here?
Yeah, I mean, I think it's a good example of just the breadth of what companies have to be thinking about now that GDPR is live and active in the world. That kind of, as far as browsing after one has clicked one of those links, I also don't know off the top of my head what sort of has been done in past examples or what Twitter's doing now. But certainly like that kind of click tracking metric is core to most of those URL shorteners. And that's, for the ones that are turning a profit on that service, that's part of the model, is you've got this user data of who's clicking what and what's going where. So yeah, I mean, turning that over, having the infrastructure to, remove or withdraw consent to that sort of tracking under GDPR. There's all kinds of issues that those, services are going to be considering now.
Disproportionate effort is the standard under the statute. Twitter can say, I suppose, disproportionate to what? It begs the question. But
right, that reminds me a bit of the All Writs Act exception, where if there's, I forget the exact language, it was the same kind of unreasonable expense or effort, but unreasonable compared to what exactly? And that's the fun, expensive, complex litigation question.
Right. So Twitter is under the microscope. Unsurprisingly, Facebook is too, for similar kinds of off-site tracking issues. And in particular, most recently, the data breach that affected so many tens of millions of users, 30 million seems to be the operative number as of CNBC's recent reporting. But 3 million of those people appear to have been in the EU. So unsurprisingly, GDPR actions are ongoing about that too. So just to let folks know that those are proceeding and may wind up in some large fines against these companies. Matt, any thoughts?
Yeah, I think that this is, I think the breadth of the GDPR is obviously significant, and I would not want to be arguing that this was, the standard of insignificant or a significant burden or something like that. I just can't imagine the European court saying that you can get away with not providing this information about somebody, because that's specifically what the law is designed to do. But when you think about like what goes into a system like Twitter, you're going to have so if it's tracking the likes, it's going to have to track who's liked them in case you unlike them. So in order to have an accurate representation of that, you're going to have to track that. And depending on how they set up their system, it could essentially be entangled, that if you're looking at who, if you have 100 likes for our podcast post that Denise puts up so well, it's going to say that this person liked it. I can't actually imagine that it's technically difficult to disentangle that. But if I have to provide you information about who else has liked your post, that could be a problem, in that the effect of the law is that you get information about other people who have liked it, although that may be public information. I just think that these are these are complicated balancing acts that the company has to try to manage. What do we give up about how we're building our software? Because could you essentially get the algorithm for what Twitter's using to build their targeted advertising or something, backfilling it by getting this information? So I don't envy them at all in trying to balance these policy considerations.
No, it can't be easy, but the GDPR is definitely something that you can't ignore. Illinois, similarly, has a privacy law in the United States that goes further than most states. We've talked about it on the show before, and Illinois has taken steps to introduce sort of a GDPR-like consent regime for collecting biometric information about people. And so one case in the news, there are over 100 of these cases pending in Illinois right now about whether people have standing to bring these cases, interpreting how the law should work. The one that was written up here at Bloomberg involves taking a 14-year-old boy's thumbprint at a Six Flags amusement park. So one of the arguments there is the 14-year-old doesn't have standing to sue, or maybe he does, or maybe they didn't procedurally set it up so that there was some person acting on legally valid grounds on behalf of the 14-year-old. Instead, the mother sued, and whether she has standing is sort of a technical challenge to whether this case can proceed. And lots of other cases pending about data that employers are gathering, and other private businesses as well. So the Illinois Supreme Court is expected to hear oral arguments soon on this. So this is something to definitely keep an eye on, because like the GDPR, Illinois here is sort of going first into this area and may be influential as to what other states and the federal government decide to do here. Fred, any thoughts?
Yeah, I think I've looked up to Illinois as the sort of first one of these biometric privacy laws. There's a few states since that have joined the fray. Washington State and Texas, I think, now have sort of similar types of laws for biometric privacy. Although, my understanding is Illinois still might be the sort of most plaintiff-friendly or most sort of aggressive privacy protection. But it's going to be a bit of a compliance nightmare for a while, until there's a federal sort of standard for this. What concerns me is that there's not more states with these sort of protection laws, given the rapid increase in use of biometric technologies in sort of every facet, whether we're talking airports or smartphones. Right.
And it comes down to how you then, if you're going to require consent to get biometric data from 14-year-olds at amusement parks, then you have to get into the question of how meaningful that consent is. And I think that we're not in a good place there either. Stefan, what do you think?
Your point about consent is really what I was going to talk about, which is as soon as you set up that threshold, it could be really a very small threshold to cross, and then you're really right back where you started. So it's not that it's a bad way to think about it. It's just anybody, hoping that resolves the underlying policy question of what do we do about the collection and use of biometric data as a point of privacy. I just don't think it's going to resolve it, because all you're doing is putting in this very, very minor hurdle. So it's an interesting law. I would hate to be a company trying to comply with it at this point. I would love to be a plaintiff's lawyer trying to bring these cases because it would be a lot of fun. But other than that dynamic, first of all, I said I think before on the show, I don't think this is a great framework for resolving these questions. Letting the plaintiff's bar loose on these kind of questions maybe isn't the optimal policy solution. But there's really sort of an interesting, going back to the Twitter story for a moment, there's a really interesting underlying problem here, which is social media allows people obviously to construct these sort of fake versions of themselves that they then put out to the public, and that's what everybody gets to see. But on the back end, Twitter kind of really knows who you are. They know what you actually click on and how long you stay on websites. And you may want the world to think that you're reading the New Yorker and the Atlantic, but Twitter knows you're spending all your time on BuzzFeed. And so on the back end, there's this like real version of you that exists that you can't access and that is valuable. And I can understand the impulse for wanting to give people access to their true selves and information about who they really are. And so it's a really interesting, philosophical question that if we're gonna answer it piecemeal, and I hope that the sort of litigation dynamics in Illinois and elsewhere don't squander the opportunity to have a thoughtful solution to this question.
Yeah, excellent observations. Matt, any thoughts?
Yeah, just to note that, this bleeds into the other area we've been talking a lot about recently, which is sort of tracking. And if you're using biometrics of facial recognition in a store, that's probably the area where you're not going to get sort of the consent where you would have it in any sort of purchase. And so, that one of the areas that if this is effectuated, it could limit the use of that in stores. And I just, as bioinformatics grow, the sort of disjointed nature of this grows.
All right. Well, we are moving into the part of the show that I teased at the top of the show, where we're going to be existentially despondent for a while here. And I think this. More so. Yes, this biometric collection just begins to get us into the issues. Cash Hill has a piece on Gizmodo describing the demise of Do Not Track, how it's never really done anything for you and appears to be a failed experiment, sadly. Because back in 2010, this was looking pretty hopeful. That we would have some way of, expressing our intent not to be ad tracked and targeted, and had various information gathered about us, even if that information isn't to be used to target us with ads, if it's just to be used to know more about the population in general. Anyway, it's a really good piece at Gizmodo, and the upshot is that the researchers who came up with Do Not Track acknowledge that it's not working. Jonathan Mayer, assistant computer science professor at Princeton University, says there's a question of whether it's time to declare failure, move on, and withdraw the feature from web browsers. Apparently, there are only two sites that are using Do Not Track meaningfully. And they're not using it completely either. Pinterest is one, and Medium is the other. So Cash Hill concludes her story by saying, Do Not Track is not doing anything to protect you unless you're surfing Pinterest or reading Medium while logged out. So pretty much everyone else, even what it appears that Do Not Track is accomplishing is that browser manufacturers are able, such as Google and Microsoft and others, are able to say, hey, we have Do Not Track in the browser, or we have it on by default, or, tell you these things that sound comforting up front so you feel good about that browser and that service. But Cash is quick to point out that although Google touts its Do Not Track capabilities in Chrome, it's not Pinterest or Medium. It's not actually honoring Do Not Track, nor is anybody else except Pinterest and Medium. So it is a sad day when this experiment doesn't seem to have panned out. And really her conclusion here, and the conclusion of the people close to the project, seems to be, it could have worked out if the government had put any teeth in the standard. If, like the do not call list, there were actual enforcement actions and fines that could have encouraged people to adopt the standard and comply with it. Any thoughts, Fred?
Yeah, I mean, crying the death knells of do not track features is something that is not entirely new. We've had folks talking about that since 2014. And I think you're spot on that, this is a well-intentioned standard that never quite lived up to something like the do not call list because, for whatever reason, just didn't end up being enforced with the same kind of teeth. I don't want to echo back to our last topic too much, but I think this is one of the reasons why I think that what Illinois and other states have done, where you are turning this over to the plaintiff's bar, makes a lot of sense. We're seeing a scale of problem that the FTC either isn't able or isn't willing to take on. And, I think allowing private rights of action for these kinds of high volume, low severity type of privacy issues is one of the stronger ways to give teeth to these kind of protections. I also think, when I hear people saying, oh, if this didn't work out, let's just remove the feature from browsers, I think that brings up another issue, which is for a less technical audience, advertising saying, oh, we've got a do not track feature. Even if that isn't itself an effective feature, it does get people thinking about online tracking and the privacy of their activity on the internet. And I think that, regardless of what the sort of right path is for the future of browser technology, and that's a question well outside my ambit, I think that sort of public education is still something that we need to be doing better. As activity tracking gets more and more complex and more advanced, and also as it transcends just online activity to, things like BLE devices tracking in-store locations of physical spaces. These are invisible threats to privacy that a lot of people just aren't thinking about. So, I think DNT, even if it's not effective from a legal standpoint, still has a public education aspect to it.
Yeah, I just hate to think that public education aspect is making people feel like they're at all private or secure. Yeah,
absolutely.
Let's make DNT DOA our second MCLE passphrase for this sad part of this episode of This Week in Law. Matt, any thoughts?
Yeah, I don't know too much about the history of the do not track, but I think that, when you're talking about privacy, if people tend to want things, I think that Stefan has talked about this and laid out the framework pretty well, that if you make things easier on people's lives, people will do them regardless of the privacy implications. And there are how viable, if you look at how many people use Google versus like something like DuckDuckGo, which doesn't track you, I think that people use Google, whether it's because of habit or because it's a better search engine, knowing that there's privacy implications for that, or at least I am personally aware of there's privacy implications that use that, and I still use Google. So I just think it's a complicated issue, and yeah, if you wanted this to be effective, you would have to have a law with penalties for it. I don't think that there's really any other way.
Yep. Stefan?
Every time we get into one of these stories, I, for some reason, go back to a case that I read in law school in torts class, and it was called Donahue versus Stevenson. I don't know if people read that case in American law schools, but it's a British case that sort of established the duty of care as a concept in tort law. And it had to do with a snail that was decomposing in a glass of soda or something. I can't remember exactly. It was some ginger ale or something like that. And that's the case that they used to, found the general duty of care. And the thing that I find striking about that case and why I think about it in this context is, before Donahue versus Stevenson, if you put a decomposing snail in your beverage and sold it to the public and someone bought it and drank it and got sick, there was no recourse for that person. And it would have been very difficult for people to imagine a recourse because there was no legal concept to hang the hat on. And you could imagine some sort of podcast in that era in the 20s or 30s, whenever it was. And they could have been talking about this and saying, oh, well, it's too bad, you bought the soda and there was this decomposing snail in it, and, too bad for you. There's nothing that you can do about it. And it would have been very difficult to imagine an effective regime that punished that kind of behavior. And I think we're kind of in a similar position now in the digital realm, where there's all sorts of stuff that happens that is functionally equivalent to drinking a can full of decomposing snail, and we feel powerless to respond to it because there's no effective regime or no principle that we can turn to that says, wait a minute, this can't be happening. And so it'll be interesting to see if the law catches up and articulates some non-controversial, basic common law principle that people can turn to defend themselves as their various rights are violated in the digital realm. And until that happens, I think we're all just drinking cans of decomposing snails.
Oh, wow. That is, I can't think of a more perfect segue to what is perhaps the best new phone tech review of all time, which Matt Honan, who is the San Francisco bureau chief for BuzzFeed, published earlier this week. It's called The Google Pixel 3 is a very good phone, but maybe phones have gone too far. And the entire piece, 7/8 of the piece, is Matt wringing his hands and tearing out his hair about what these technologies that we all use every day and don't think about that much while we're using them are actually doing to us and those around us, primarily in data collection sorts of ways, but also in, he he points out at the beginning that he's texting his colleagues on Signal and then puts a footnote down at the bottom that says something along the lines of, where is the footnote? Because we use Signal because God knows that everything we say can be listened to and probably is. And we use Signal to communicate because it is encrypted, and God only knows who is listening in or trying to in this age of perpetual voluntary surveillance. So it starts out on that note and proceeds from there, really making you think about all that goes on with your phone. But by the way, he really likes the Google Pixel 3. He thinks it's a good phone. So did you have a chance to take a look at this, Fred?
No, I didn't have a chance to check out that article.
Yeah. Do so when you're not, in already in a bad mood or state of depression, because it's sobering to say the least. He at one point says he wanted to, for purposes of writing this piece, chronicle every bit of data that the phone was gathering about him over the weekend, and he just gave up on that. He didn't think it was actually possible. So it's good perspective. His other footnote in the piece is at one point he just comes to the conclusion that maybe the only solution is to throw your phone into the ocean, and then he footnotes that and says, no, don't do that. It would be very bad for the oceans. So really, he leaves us in a state of we're all going to joyfully, buy the new shiny thing, and you just need to be aware that this is what you're buying into when you do that. And I think that's what you were just saying, Stefan. Correct?
Yeah. Yes, absolutely.
Yes.
With more decomposing snails, though.
Yes, we are. You have bought the phone, and it is replete with decomposing snails. Matt?
Yeah, I think this is always an interesting dichotomy of, any technological advance. There's always sort of this deep desire to join into the fray and deep apprehension about what it comes out in the future. I always think about, I don't think so far back to England, but when cars started coming out, there was local laws everywhere about how you couldn't drive your car in certain areas, and how they were this nuisance and they were ruining the horse and all of this. And that's some of what that sort of angst of, we don't really know what we're getting into. We know that there's unforeseen consequences in it, and I just you just feel the angst just coming through this article.
You can. And lest we sort of leave you down in that angst-ridden, depressing hole, let's also talk about the fact that Alex Stamos was a person who for years was with Facebook. He was working on defending the company's systems against Russian interference and other critical threats. He has moved on to Stanford. He's an adjunct professor and a Hoover Fellow there. And he has started something that may help. It is called the Stanford Internet Observatory. Its purpose is to help unite sometimes warring factions of academia, tech companies, and Washington policymakers to work together to help solve the negative impacts technology can have on society. So at least Alex has not thrown his phone into the ocean, as detrimental as that may be helpful to him personally. He has decided to do something productive and try and find a way for these disparate but interested, important decision makers to come together and work toward a world where we don't need to throw everything into the ocean to salvage what's left of our souls. In fact, the remarks that he gave featured in the Washington Post here were called "Battle for the Soul of the Internet." Matt, did you take a look at this?
I got to take a brief look to this, but that is a big task that he and the Hoover Institute are taking on. I really enjoy the Hoover Institute, but that is a monumental task that they're proposing a solution to.
Indeed. What do you think, Fred? At least we can't just put our heads in the sand, right?
As convenient as it would be after throwing our phone in the oceans, no, we can't just put our heads in the sand.
You're right there.
That's right. You're right there.
I read this article, and I think it's a step in the right direction. But I have to admit that, considering Facebook's constant troubles and constant missteps with privacy and with sort of user security, I'm skeptical of putting this kind of important task in the hands of someone coming out of that space. And I'm, if anything, more concerned by talking about this as a space for academics and industry actors and government actors only to discuss the future of the internet and of privacy. Those are not the people most endangered by what we're seeing coming out. And I think that having a space for public democratic forums to discuss the way forward is, in my eye, much more important than this kind of echo chamber of industry and government regulation. Without that crosstalk, I don't think one really helps out the other.
Yeah, good point. I mean, I'm hoping that organizations like EFF and EPIC would be involved in this, but
I would hope so too. But
yeah, that remains to be seen. All right, so now that we've depressed you, let's go to something. How do we all escape our existential angst about what devices are doing to us? We might play a video game, watch a movie. Let's talk about some entertainment issues. So this is pretty hilarious and also reminiscent of something we've talked about on the show over the years, namely the Bikram yoga lawsuits attempting to copyright Bikram's yoga series, which did not go well for Bikram. Now we've got Fortnite in the crosshairs, and various hip hop dances created by hip hop artists are, they say, showing up in Fortnite as part of its emote feature, which is probably my favorite feature. I've never played Fortnite, but I have watched it being played, and I could sit there and watch the little avatars dance all day long. They're hilarious. And apparently the players like that feature too. But who doesn't like it are various hip hop artists who nobody's actually sued yet, but lawsuits are being threatened against Epic Games. in particular, let's see, Brooklyn rapper 2 Milli has threatened to suit against Epic for allegedly stealing his signature Milli Rock dance and giving it the new name of Swipe It. So this gets us back to the copyright principle that musical notes aren't copyrightable, but songs are. Particular dance moves aren't copyrightable, but dances are. So it will be interesting to see how this plays out and how the various parties emote their way through any litigation that ensues. Matt, any thoughts?
Yeah, I think that this would be a hard case to win. I don't know that much about hip hop dancing, but I would just assume that whoever came up or invented these hip hop dancing, like, certainly would have seen other people doing these moves. So I guess maybe if you tied it with the lyrics, I don't know if they play the music while they're doing that. I think you'd have more of a case there. But yeah, if this follows sort of like the most copyright law where you can't shorten things aren't copyrightable, then this would seem to make sense. But yeah, I mean, I think it's very difficult to say that, like, especially for like one move dancing. If I'm shooting the hoop in my dance, it'd be very hard to say that even if I made it famous, that doesn't mean that I have the copyright for it.
Yeah, there's no doubt that it's a critical part of the game, just like the name, image, and likenesses of sports figures are critical parts of some video games and have put those game manufacturers in the legal crosshairs as well. And I think it's still sort of a free-ranging legal atmosphere as to how those people are going to be compensated or not. Any thoughts, Fred?
Yeah, I haven't followed this extremely closely, but it reminds me a lot of, I think it was Blizzard that filed suit against a few people who'd made some game mods. Mm-hmm. And, it's, I think, a great example of, where the ethical and the legal kind of part ways to a degree. Mm-hmm. I think that from a sort of legislative and policy standpoint, it would be a disaster to allow individual dance moves to be registered copyrights. And, I would be afraid to go to a club without, a liability indemnity agreement.
We won't even say Kanye's password.
Right.
Right.
At the same time, is that a good and right thing for the company to do? And, should they be taking dance moves from others without their permission or consent and then using that as marketing? I'd say probably not, even though legally I agree. I think there'll be a very difficult copyright case unless you really want to push the boundaries of, how much dance move do you need before it becomes a copyrightable dance arrangement?
Yeah, this is going to be interesting to watch and see if we do get some new law in this area. Stefan, any favorite hip hop dance moves you want to highlight for us?
Yeah, lots of them. But I will kind of take the opposite side here, just for fun. Sure. I could understand the concern of the hip hop artists in this situation because they are probably familiar with many instances in which something that is not protectable by copyright or other IP laws ends up getting incorporated into something that is protectable. And then that thing gets protection and money and everything, recognition, mm-hmm. everything that flows with IP protection. And there's this weird disconnect where the originator of the idea is left with nothing, and the person who sort of copied it and made some minor adjustments to it, incorporated it into something that is legally protectable, can then make a lot of money from it. And I think there's a lot of examples on the patent side that people talk about in more academic circles about, traditional native medicines, for example, that end up getting incorporated into patented medicines one way or the other. And then there's this sort of weird disconnect where the discovery comes out of indigenous knowledge, but indigenous people are not compensated for it because they can't, based on the way that they practice the medicine. And I think, echoing the point about this being an ethics versus legal question, I think that's fair. I think if I'm on the side where the ethics are on my side, but the law is against me, I'm going to speak up and give voice to that. as much as possible, even if all I'm doing is raising awareness. So I can understand the impulse, and there's certainly many examples that you could come up with where a similar dynamic has played out and left a creative community without recourse or recognition. And so given that the purpose of the law on some level is should anyway be to align with ethics, I can understand this very funny sounding issue to actually have a lot of dimensions to it. So I'm at least conceptually on the side of the dabbers and the that I guess dabbing is the only hip hop dance I can name right now, but but I have
we
many.
just told you
many
one. Swipe it, right? Or no,
Swipe
that's
it.
not
Okay,
originally what it was called.
No, whatever. Yeah. In any case.
All right. Well, one other video game related story that actually, there we go. I just think of that one as the Backpack Kid, but I know it has another name. Always fun to watch the video, folks. If you're an audio only subscriber to This Week in Law, Victor does a great job of illustrating what we're talking about. Let's go back to facial recognition for a moment and take a trip to China while we're at it. There is a video game company in China called Tencent. They have the most downloaded and profitable mobile game called in the world, I believe, called Honor of Kings. And one of the things they're doing because of the different legal requirements in China is they are instituting facial recognition to identify their players in general, but also in particular to identify minors. Because in China, they do not just stop at rating games and saying minors shall not be able to buy them and shouldn't play them. They want to actually stop them from playing by using biometric technology intercepting them and saying you're 14 and can't play, or whatever the case may be. So I am torn about this as a person who pays a lot of attention to law and policy. It's terrifying. As a parent, it's way more effective than anything that say we have in place in the U.S. And the Chinese government seems to be stepping into that parental role on behalf of the youth of the country because they feel strongly about various games and their impact on youth. So what do you think of this, Fred?
Well, you're right. It raises a whole lot of different issues. And I think, when I'm thinking of comparative examples in the U.S., I think of, is it CalAPA or CAPA, the privacy, sort of Children's Privacy Act?
Yes.
Which, the
CAPA.
practical result, yes, CAPA, thank you. The practical result of which was now your, website terms of service or privacy policy says, don't use this if you're under 13 unless your parent or guardian says that's fine. But, I think it's a great example of sort of where you draw the enforcement line. Is it enough from an actual prevention standpoint? Probably not. But, I think the only alternatives you have are things like this, where it becomes quite sort of extremely invasive. And that's tricky. I sort of hear what you're saying about, on one hand, this is invasive. On the other hand, if I agree that this is something that should be stopped, this is one of the more effective ways to do it. And again, assuming that the facial recognition technology is reliable, which is, I think, a not small assumption. Has this been tested on, I'm thinking of facial recognition training data is often drawn from, let's say, insufficiently diverse data sets. So, it might recognize a certain sort of look of person just fine, but, if I'm of a appearance that is outside what that data set was full of, is it going to misclassify me? Am I, because I look especially young, now not going to be able to visit that website or use that mobile game? Mm-hmm. I am concerned about seeing the same sort of misenforcement we've seen with, for example, like automated DMCA notices, where because the algorithm is wrong, you get enforcement where it shouldn't be, or lack of enforcement where it should be, and it just seems like we end up at the same problem of we can't enforce this reliably, even if we can do it automatically. And that's, I don't know, you're trading one bad for a different one.
Right. Stefan, this harkens back to what you were talking about tracking technologies and people copying to reading BuzzFeed. And by the way, I think Matt Honen's piece in BuzzFeed sort of blows up our analogy here, as opposed to the New Yorker or the Atlantic. If people are being, facially recognized, not just for youth purposes, but apparently they're using biometrics as their way to access for all users. They just have this added feature of if you're particularly underaged, then you're going to be prevented from playing certain games. So I guess I'm just glad I don't live in China. What do you think, Stefan?
I think another topical story that dovetails with this one is Elizabeth Warren's DNA announcement earlier in the week. And they both stories speak to an essential problem in the way that people live their lives and how that is impacted by technology, in that most people would portray themselves as truthful and would value honesty. I think very few people want to automate the process and subject it to sort of the technological scrutiny of whether they're actually being truthful, because I think social norms around truth and honesty and reality are not constructed around sort of the pneumatic kind of automated technological threshold of what that means. In other words, you want to retain some ability to fudge things, and you want to be able to have those situational, adjustments. Let's say, you're a parent and you want to let your kid get away with something. You want to retain the discretion to do that without necessarily subjecting it to facial recognition technology and government oversight about what is and isn't acceptable. And I don't think people have fully thought through what it means to subject themselves to that level of rigor and require that much honesty and verification in their lives. And it'll be interesting to see what happens when people are more uniformly, more rigidly held to account. And at that point, who gets to determine the standards of what is true and what is acceptable will become much more consequential than when that's simply a standard that's articulated and then left to every individual to live by or not. And I think we'll lose something in what we consider our common humanity when we're no longer articulating those standards on our own.
Yeah, well put. Matt?
Yeah, I think that this is, as bad as our constitutional hair splitting is that we have to go through the United States in order to protect some of our civil liberties. It's really nice that we have them. China gets to do what it says it wants to do. This is it. They had the one-child policy forever, and that was very effective in keeping population down. But you infringed on a lot of liberties and in the process. So, I'm glad that we don't have any sort of policy like this.
Very much so. All right. So, although again, as a parent, you struggle with how much access you want your kids to have to various media in their lives. All right, let us move on to talk about some issues relating to artificial intelligence and robots and the Internet of Things. In other words, cue the dancing bot dog, Victor. Boston Dynamics has released some promotional videos showing their, I believe it's the Atlas robot that can parkour, and the Spot Mini that can dance worthy of Fortnite. Can we play that, Victor, please?
Girls hit you, hallelujah. Girls hit you, hallelujah. 'Cause Uptown Funk gon' give it to you. 'Cause Uptown Funk gon' give it to you. 'Cause Uptown
Presumably they licensed the music. No word yet on whether they licensed the dance moves or if the artificially intelligent robot is making up the dance moves as it goes. but it is definitely worth knowing that robots can dance better than you can, or maybe not. What do you think, Matt? You think you can outdo the parkour? How about the dancing?
I'm not saying I could outdo the parkour. I'm just saying I could do the parkour. And there's certainly no level of dancing that I have. So the robots got me.
What do you think, Fred, about dancing robot dogs?
I've got to say, for a robot seated deep in the uncanny valley, that's a pretty good moonwalk.
I would have to agree. And Stefan, any thoughts come to mind?
Yeah. So the robot dancing is one thing. That what I found really interesting about that particular story was the reporter talking about it in her tone, in her sort of vocabulary, and how she was presented. It was this like really bubbly, optimistic. She may as well have been describing, a new line of bubble gum. But what she was talking about was really like a really interesting and potentially daunting development in war technology. Like, I'm sure the Department of Defense is heavily involved in Boston Dynamics one way or the other. And so it just makes me think that when sort of robot fascism descends on our world, it's going to be, blessed with this nice overlay of young, well-dressed, peppy reporters sort of commenting on it in this aw shucks way. And everyone's going to think, hey, this is great. We've got these dancing robots. Wonderful. So it goes back to my sort of general point that I often make, which is it's all about user interface design and the the user interface of the robot apocalypse is going to be great. And so this is why science fiction tends to bore me, because the aesthetics are always so, dreary and depressing. And what it's really going to be like is super fun. Everyone's going to be happy and smiling and young. And you're going to be left with a sense of, man, I really want to be at that party. And you're not going to want to be left out. And so that's why we're all going to become robot fascist supporters. So.
Wow. Now I'm back to being existentially depressed again because you're dead on. All right. Well, as far as the legal overtones of what we just watched, there are a couple of great pieces in our rundown that I encourage people to check out about this Christie's auction that's going to happen. When is it exactly? It's coming up. I don't know exactly when, but they are going to be, in a month. They will be auctioning the first AI-produced artwork to be sold at a major auction house. And they're estimating that it will sell for between $7,000 and $10,000. It is this sort of strange creation. It's a portrait of a gentleman, and it's got sort of this fuzzy impressionistic aspect to it that kind of reminds me of the terrible restoration of the artwork in the church. It's sort of that like strange, weird, fuzzy face thing. But that doesn't mean that it won't do well at auction. So actually the site artsy.net has a super interesting piece on all of the ramifications of selling AI art, ownership of the art, owning the code that generates the art. It's owning the training set that created the AI that generated the art. So it's a super good deep dive on the ramifications of this, and I'm tying it back to the Boston Dynamics robot and its own training set for coming up with its dance moves. I have no idea whether that was fully programmed or off the cuff on the robot's part, but I suppose that we should also talk about the hip hop artists that might decide that Boston Dynamics is ripping off their dance moves there. Any thoughts about the world of AI generated creativity, Fred?
Yeah, I mean, I think it's absolutely fascinating from a copyright perspective. I keep thinking about what Stefan said a bit ago about the discretionary function and how AI and automation and sort of the increasing sort of computerization of these things changes that. And I think that's, whether we're talking dancing robots or AI generated art, I think where we start to see the questions that I find really, really fascinating is still in that science fiction world where the AI has a choice over whether or not to make art or whether or not to dance, and if so, how. So this is neat, but it seems more like AI being used as a paintbrush and easel as opposed to making art itself.
Yeah, I'm with you there. Matt, what do you think?
Yeah, I think the article does a really good job of breaking down the sort of elements of what we would, what sort of things go into building this. Is it the training set? Is it the algorithm? And I think if we look at like most consumer applications, if you put a filter on your picture with Instagram, I think it'd be assumed that you have the copyright to the photo, even though clearly it's the Instagram filter that's making it, whatever it's making it, or at least plays a part in it. So I think that in most instances, if there's if I have a SaaS model that's offering an algorithm with a training set and you put your stuff into it and come up with something, I think that at least from a business perspective, I'm incentivized to give you the copyright for it. It's different in an open source environment or, something like that. And I think it does get really complicated when you're using, copyrighted works to train your set. I think that will be a really fascinating analysis. If you use one copyright to train it, is that analogized to me looking at a copyrighted work and taking it as inspiration, or is it a factual determination that this added something to it? This is X percentage of the work. That's something I hadn't really thought about, but I think it'll be really interesting to watch. And how cool is it that this is happening?
Well, I don't know how cool it is that it's happening. I kind of feel like it's the robot apocalypse with a great UI, like Stefan was saying.
I'm very excited about that. I'm one of the cool kids at the party, so this is great. I don't know. I'm not an artist myself, but art has taken many different mediums. I think that it will survive this one, right? I think that. Is it dystopian that instead of having to draw a picture, you can take a photograph? At the time it may have been.
It was at the time. There's actually a whole lot of history in the art movement about the pushback against photography as a fine art form in the early days of it. So yes, I think the analogy is strong there that, the doom and gloom from the art world is going to continue on this for a bit.
We live in the era of EDM artists who stand at the front of an arena in front of an array of electronics and just kind of wave at the crowd and push buttons. So
he hated Bob Dylan when he went to Electric, and he created great music after that. I tend not to be as overwhelmed by changes in technology, and if you think about if the point is to be emotive in art, and you think that it can only come with people, then only people can create it. The problem with art though is it's much about the observer. Is it about the creator? So, but I think that this is not a new doomsday phenomenon. We just had this doomsday for a while.
And Virgil is pointing out in IRC that we've moved straight into the realm of Star Trek scripts. I wasn't much of a Voyager fan, but apparently on Voyager, the doctor on Voyager wrote or programmed a holo novel, and he had legal issues. So we're bringing those things to life. Stefan, any final thoughts?
Yeah, I just anytime this AI stuff comes up in the art realm, there's always a focus on the market. For example, I think one of the stories here was talking about how this was the first time that they were going to be selling this, and they're expected to get $5,000 to $7,000 for this. And I always think about the art world as having many different kind of layers to it, one of which is the commercial layer, and that having very little to do with sort of the question of what is art. Like at a certain point, art became a really good way for very rich people to hide money. And so anything that's happening in sort of the auction circuit in the art world, I think is just completely divorced from the underlying question of what is art, and should we be concerned about the implications of AI on the questions of sort of the emotive experience of art. I just see it as very different from the commercial aspects of art. And so I thought the story was interesting from the perspective of they're now predicting that there's going to be an actual market for AI art, because I think that is actually something that's quite new. And I wonder where that's going to go, because the value in art often just comes from, it's almost like you're speculating on a limited on a limited commodity, and if it's being created by AI, how do you limit it, right? Because an artist who dies young and is then deemed brilliant and has only created 100 works, then you've got a finite set of what that artist has done, and all of the value in that art comes from the fact that people want to hide increasingly large sums of money in a finite product. When it's an algorithm that is just endlessly creating new stuff, how is the market going to limit it? What's going to make it finite, and how are you going to convince people to hide their money in it? Is it that not to sound like a total cynic, but that and
then self-destructing algorithms.
No, that's right. I mean, so this is where the Banksy story kind of becomes interesting. I find Banksy kind of boring, but this if you did have a self-destructing algorithm that died at 27 and joined the 27 club, could the limited run of the work that was printed while that algorithm was still active become valuable in the way of a old master who only did a set number of volumes? Maybe. Otherwise, what you're going to do ultimately is just actually, what you could end up doing, now that I think about it more, is you could actually eliminate the commercial equation altogether and really force a conversation about what is it about art that people truly value. Because once you take out that finite quantity and it becomes about actual preferences and what people find beautiful, you could either end up in a situation where people are focused on art for art's sake, or you could have the kind of multiplication of the mediocre, because most people have bad taste, and that's what's going to end up becoming popular. So it'll be a really interesting question, I think, on the essence of art once this happens, and I'll be interested to see how it's analyzed.
Yeah, absolutely. And just as a PS to that, there are times when the television show Keeping Up with the Kardashians provides us good fodder here on This Week in Law, particularly with regard to location tracking technologies, et cetera, because their family members all tend to use technology rather aggressively to live their lives in public. But this is another episode or instance where I get to reference the Kardashians. I have no idea which recent episode it was, but they grappled with the very problem that you're describing, Stefan. They played a prank on Kris Jenner to have her fall in love with a supposed new and up and coming artist, when in reality, and start to spend oodles of money on works of art that they all talked up as, oh yes, you're going to love this new artist. And in fact, and they introduced him to some guy who was not the artist at all. And the art was being created by daughter Khloe Kardashian, who produced huge works of what looked like pretty legitimate art simply by slashing paint around, et cetera, and putting them in a nice frame. So right to the heart of those issues. Let us move on to our concluding material for the show. I'm giving myself a pass on giving you an actual animal selfie and an actual tip of the week. We'll have sort of reasonable facsimiles of those, and we'll have actual resources as well. So let's cue that animal selfie first. Okay, so sometimes we have to show you things that are not animal selfies so you have a basis for comparison. I think there's no question as to who would own the copyright in this photo of this cat so nicely lined up with the starters in the track and field race that is about to ensue. Listener Jonathan sent this in, and it's just such a delightful picture. We had to share it with you. However, of course, were this to become a famous and sought after and commercially lucrative piece of art because it's such a delightful picture, perhaps the copyright in the actual broadcast behind it would come into play. So there is our animal selfie of the week. Our tips of the week are twofold because we're coming up on Halloween, and we're still discussing Banksy and the shredding of art. So listener Ray Hill sent me a link to a Twitter post. I have no idea what the source of this is, unfortunately, but it is your Banksy Halloween costume, which is a shirt with the Banksy photo, and it is shredded at the bottom, which just seems like the perfect costume for this year's Halloween. If you wanted to wear such a thing, if you wanted more of a two-person costume for Halloween, there is this fabulous thing that Ian Laking, IH Laking on Twitter, found on Reddit and then posted. It is a video of a DIY mech costume with dad in the back and daughter in front piloting the quote unquote mech, which goodness knows, if you want to be dad of the year, this thing just rocks. And as long as we are talking about Halloween and we have Fred on here, Fred, you've gone to the trouble of actually changing your it's not your Twitter handle, but it's the name that pops up for you on Twitter to reference a very Halloween oriented case. Why don't you tell us about that?
Sure. So I first heard of this case because we covered it in my 1L property law class, but it's a case where the house that had been purchased by plaintiff, who was now seeking to rescind the real estate contract, was legally declared to be haunted. And this comes out of a New York Appellate Division case where New York is a very sort of buyer beware state. There's the citation if you want to look it up, but the short version is that the court looked and in a decision laden with ghost puns, said, well, we can't expect people to, hire diviners and various spiritualists to figure out if the house they're buying is haunted. We're not going to get into that morass, but we know in this case that the seller took steps like having the house listed in like a book of haunted places or on like the local ghost tour. And the court sort of looked to these tangible steps the seller had taken and said, well, you made this reputation. It couldn't be easily sort of surmised by a buyer. It's not like a house inspector is going to notice that. And so you have an affirmative duty to disclose it if you want this to be a non-rescindable contract. So I just find it like it's both a fun case to read and sort of a weird niche issue of what does the reputation of a haunting do to the market for a house.
Absolutely. We also, Fred, thank you for digging up, and this can be one of our resources of the week too. The episode that Virgil was referring to of Voyager is called Author, where the Doctor completes a work on a hollow novel that depicts the crew of Voyager in an unflattering light. So there you go after the show when you need to dive into some TWiL related entertainment. There's a great one for you. Our resources, other than that, we've got a couple more. One is you'll remember that we mentioned something called Moral Machine, which was a project at MIT where you could help solve problems that could be used to train autonomous vehicles to make the right decisions in difficult situations. This is not quite as dire in nature, but it's a game and it's called Learned Hands. It's a joint project of Suffolk Law School's Legal Innovation and Technology Lab and Stanford Law School's Legal Design Lab. And the point of Learned Hands is to have people spot legal issues in stories about their problems. So what's going on here is an attempt to use crowdsourcing to have an algorithm be able to spot legal issues the way an ordinary person would. And the whole usefulness of that is to help create a taxonomy of legal help issues in language that lay people can understand, and to train a machine learning algorithm so that they can recognize legal issues in the way lay people would discuss them, and then be able to, solve them. So look for Learned Hands if you are interested in contributing to that project. And it's a game, so hopefully it's fun as well. And then our second resource, we may have mentioned this on the show before, but if not, it is due for a mention. It is called Lumen. It is a project of the Berkman Klein Center at Harvard, and it is the database that studies cease and desist letters. It is heavily supported and used by Google. So when things get taken down from Google because they've gotten a takedown request, they go into this database. So you can find things, you can find out all kinds of things about what's being asked to be taken down from Google by going to Lumen. And Google actually points you there if you are searching for something that has been taken down. So I threw it in for us this week, Stefan, because I needed a way to ask you if you're watching the Romanovs and what do you think of the fact that we now have Bolsheviks on a major entertainment platform, aka Amazon. This is an Amazon original. There have been a couple of instances where people have attempted to post pirated versions of the Bolsheviks, and they've been removed from Google. Any thoughts, Stefan?
I've not watched it yet. As a big fan of Mad Men and Bolsheviks, I should watch it. I haven't had a chance to do that yet. I thought it was about the Romanovs, sort of in modern. It is instantiation. So I didn't realize it touched on Bolsheviks, but that'll be be interesting.
Every episode, and I have watched the first two of the series, and they're long and good. I mean, I definitely think it's worthwhile television. The second one is a very legally, procedurally oriented one. Involves a criminal trial, among other things. But the opening credits, Stefan, involve the original Romanov family being slaughtered. So there you go. The Bolsheviks feature strongly in both sort of the historical discussion of the show, because the thing that ties the episodes together, they are all standalone, but every single one of them involves someone who claims descendancy from that family, and presumably from Anastasia, because she's the only one who got out, right?
I don't think the Bolsheviks actually admitted, though, that they killed them. So, I'm not so sure if a misfact is put into the story. Is it about the Bolsheviks?
Maybe.
At least if it parts from party line.
No, they were proud of it, but they absolutely admitted to it.
All right, then we have
they may have later tried to cover it up, but
but they destroyed the history of it in the 40s.
Our Bolshevik fact check of the week.
We still need the bumper.
Yeah.
We do. All right. Well, gentlemen, this has been an existentially difficult and yet really fun episode of This Week in Law. Fred Jennings, it's been such a pleasure meeting and hanging out with you. Good luck with everything at GitHub.
Thank you.
We're thrilled about your new adventure and hope it all goes great.
Thanks very much. I'm thrilled for it, too. And thanks so much for having me. This was a lot of fun.
It was a lot of fun. Is there anything you'd like to leave our listeners and viewers with before we go? Anything that's coming up where you're speaking or writing or anything at all you'd just like to highlight?
My sole focus right now is this move. I don't have any sort of big things planned other than that right now. So, I'll have to pop up to Petaluma when I can, and we'll update from there.
Yeah, that would be really fun. Definitely stay in touch, and good luck with everything. Matt Curtis, such a pleasure to see you again. Thank you so much for joining us today.
Yeah, great to be here. We'll have to include a small segment of death rights law next week, since it's approaching Halloween.
We should. Yeah, that's a great idea.
Rights of the dead.
We'll look at that.
But it was great to meet you, Fred. Hopefully you get to. I see the helmet in the background. I hope this means that you get 4 year round or the fall, winter. You get to ride your bike all the time. So this will be great.
That's the hope.
Yes,
you got to get some lighter hours from GitHub in order to do that.
Right.
Definitely, if it's not already on your list of things to do, ride over the Golden Gate Bridge and ride your bike in Marin. It's beautiful way to spend an afternoon. Stefan Schweida, so great to have you on the show again this week. Thank you for everything.
Thank you. Lots of fun topics today, and good luck, Fred, in the Bay Area. It's a reality distortion field, but that's a wonderful thing about it is that it can scramble your brain for a while, and you can forget about time and place. So,
all right. Yes, you'll have to update us, Fred, on when. Just tweet it out, and we'll find it and share it with folks and let them know that it happened. Your first ride-shared or shared scooter ride in San Francisco, you must share with us.
Right. I think I'm required to leave that in the middle of the sidewalk afterwards, right?
You are. Yes. That's how it works. So let us know how that goes.
Will do.
All right, everyone. Thank you so much for joining us for this week at This Week in Law, where we do the show every week on Fridays at 11 o'clock Pacific time, 1800 UTC. That's when you can go to twit.tv and join us live and jump into IRC, technology of which is 30 this week. Oh my gosh, we're using a 30-year-old technology, but it's an oldie and a goodie. Jump into IRC with us and play along with the show live if you can. If you can't, head on over to twit.tv/TWiL. There is all kinds of information there about how to subscribe to the show, how to watch the show on your own time, on your own device of choice, whatever platform you use. If you have the ability to take a moment and drop us a comment or a review, those are always helpful. We really appreciate your time, not just joining us, but if you take that extra step, all the more so. We would love to hear from you between the shows too. I'm Denise at twit.tv. Matt is Matt C at twit.tv. Stefan, you can email at his law firm or just email me and I will share your thoughts with him. And let us know on social media the things that you are spotting there that you think are interesting. Twitter's a great place to do that. We have a Facebook page. As long as they'll let us have one, we have a Google Plus page. So hit us up on any of those forums that's most comfortable for you. Let us know what you have spotted in your journeys around the web that you think that we need to know about here on This Week in Law, and also people you think we should reach out to and invite on the show. So with that, we'll leave you for the weekend. Have a wonderful one, and we will see you next week on This Week in Law. Take care.